You're running out of time to save you and your family some money. We're going to talk about wills and trusts next on Due Process.
Major funding for Due Process is provided by Meade Lexus of Southfield and Meade Lexus of Lakeside, offering a large selection of new and pre-owned certified premium vehicles.
Don't just reject convention. Drown it out. Introducing the all-new 2013 Lexus LS F-Sport, an entirely new pursuit.
And by WWJ News Radio 950, keeping you up to date with the latest news, traffic, weather, sports, and business information 24 hours a day, 7 days a week. Live, local, and committed to Michigan's future. News Radio 950, WWJ.
Thank you. I'm Henry Baskin, your host for this edition of Due Process. We're going to talk to you about how you save yourself and your family money. We're going to talk about wills and trusts with Judge Debra Nance. Welcome to Due Process.
Thank you.
Thank you for being here.
Thank you for having me.
I know that in your practice prior to becoming a judge, you dealt a lot in the probate, what we call wills and trusts and estates, right?
That's correct. I was actually an estate planning attorney, but I also did a lot of litigation work, so I was a probate litigator. I had an opportunity to see what happens at the end if the wills and trusts aren't done properly.
This is interesting to me because you watch TV and it says LegalZoom will get you, for $90 will get you a will, or get you a trust, or get something. Or you can write one out, someone else said you can write it out by hand. There are all these myths, and people, for some reason, just delayed doing it. We had an example the other day, I should say the other month, where a divorced mother who had 2 children and had a lot of money given to her in the divorce, she died. She died, unknown causes, no will, nothing written. And now they're stuck in litigation, the ex-husband, the children, and things such as that. And there's a way to avoid it, isn't there?
There is a way to avoid it, and it's called just that, a will. And a will, Henry, is nothing more than a written instrument, and a will is written. Cannot in the state of Michigan be verbal. It has to be in writing.
Okay.
And it's a document that can be done by anyone over the age of 18.
Okay.
Who knows who they are, because there's a capacity or an incapacity issue.
So age 18 would
Age 18. They have to know who they are, what they own, and who they'd like to distribute it to.
Okay.
And it's simply a matter of putting that information in writing, dating it, and signing it in order for it to be valid here in the state of Michigan.
So that sounds simple. So I sit down and I say, okay, I'm a single mother, I have 2 children, I'm going to write this out. If I die, I would like money to go to so-and-so, and so. I don't know what the wording would be, but it sounds simple. It sounds like this is what happens when I die. I mean, I don't forget about taxes and things. Would that be honored by the court?
It would be honored by the court if there are certain issues in place. For example, it has to be something in writing that is intended to distribute your assets.
Okay.
So it has to be intended as a will. And I'll give you an example of that. I was once involved in a litigation matter in which a father had written a number of letters to his son who was in the military fighting. And in this series of letters, he'd given him some indication of what he might leave to him. He, however, had a separate will. So the letters were offered to the court as the will of the father.
The real wishes of the father.
As the real wishes of the father. But what the judge in that case decided was that there was actually a will which left his assets to his siblings and not to his son. The letters written to the son were merely nothing more than letters to keep the son encouraged and motivated, but they were not intended to distribute his assets.
Okay, so there has to be the intent.
There has
In
to
other
be an
words,
intention.
simple wording. I intend upon my death, I intend that this money in this bank or whatever I have will be divided between my children.
Yes, and judges are also typically looking for language that might say this is intended to be my last will and testament,
Okay, well,
as opposed to simply a letter of encouragement or something that
is
I'd
it
like to say.
possible for someone who's watching this program to sit down and say, you know what? The inevitability of death is always there, but accidental death and things such as that. Can I write this out by hand?
You can write it out by hand. It can be handwritten. That's called a holographic will here in Michigan. Again, as long as it's signed and dated. It does not have to be, I think there's also a misnomer that it has to be witnessed. Here in Michigan, it no longer has to be witnessed. It just simply has to be signed and dated. Sometimes individuals will have a will witnessed if they believe that it's a possibility that the signature may be challenged.
I
That
see.
someone may come along later and say, this really isn't Dad's signature, or this isn't Mom's signature, someone else forged or signed on their behalf. If that's the case, you might want to have the additional safeguard of having it witnessed, but it's not required.
Okay, so that's pretty simple. And everybody here in this studio and everybody watching should sit down and say, hey, this is what I intend to happen, what I would like to happen upon my death. Is there also something that would give somebody some power over your assets if you're incapacitated? Say you have dementia, say you have Alzheimer's, you're living. How do you take care of that issue?
Well, what you want to make sure that you're doing, first of all, is creating at least one document called the will that distributes the assets.
Right.
There are opportunities to also create what is called a trust, which takes care of other matters as well. But typically when you are designing a will, you have the capacity, you have the mental capacity to again determine who you are, what you have, and who you would like to distribute those assets to.
Okay, so you and I have both seen a lot of wills written by people and terrible court fights. I talked to a family of 9 brothers and sisters, and they said, here's the will. Well, that didn't mean they went and hired 9 different lawyers, and they're down in Wayne County fighting over this estate. And I'm thinking, wait a minute, the man made a will, and he was of sound mind. He knew what he was doing. He knew who he was. He knew what he wanted to do, and he said, this is my last will, and he signed it. Now, there was a trust involved and things like that. But why is it that we keep seeing these cases where people are fighting, and when you went out to probate court, they're all lined up in the hall waiting to argue over who's entitled to this. And I don't understand what the issues are. It sounds simple to say, I have a will. This is what I want done. Now, if you have young children, how do you take care of that? Because you certainly can't say, I want my 12-year-old to have this and my 14-year-old to have that. So, there has to be something intervening, I assume.
Well, let me go back to your first question as to why there's sometimes so many people fighting and why the litigation,
Right.
even if you have a will. Wills can be challenged. Even if you have a written instrument that indicates exactly how you want to have your assets distributed, there can be other people who can challenge that will. Usually a will, however, can only be challenged if there's the possibility of fraud, undue influence, or duress.
Okay.
And that is typically the challenge that heirs or those who did not participate in the will bring a litigation or bring a challenge to the will because they believe that the person who created the will was either under undue influence by
I see.
someone else
Okay.
to leave them items, or because they believe that there was some fraud.
When we come back, we want to continue our discussion and see why there is such enmity that goes around these issues when we go out to court. We'll be right back after we take a break here.
Thank you.
Thank you.
Legal referrals and more information on this and other related topics are available on our website at www.dueprocess.tv. There you'll find information on today's program, helpful hints to legal issues, support materials, and lawyer referrals. You can also stream previous episodes of Due Process.
Okay, we're back on Due Process. We're talking about the enmity, some of the anger that you feel when brothers and sisters are fighting over someone's will, who say, well, wait, I have a son, I have a daughter, I'd like them to have my money, and then people start fighting over it. And I just wondered, what happens. Before the break we said, well, we're going to figure out what happens to the children. The children are given the money. Sometimes it's a lot of money, but who takes care of that? You can't have a 12-year-old walking around and saying, oh, I just got $500,000.
That's exactly correct. A will is also a perfect place to name who will be the guardians of your minor children.
Okay.
It's an opportunity to at least nominate the guardians. Now, the appointment has to actually happen by a judge,
Okay.
but a will is a wonderful place if you have minor children to state in that will who you would like to raise those children in the event of your untimely death prior to their age of majority. If those children are, if there's a distribution of money to those children, they also have to have a conservator.
Oh, they do.
Accept money on behalf of a minor child.
So that's another person appointed by the court?
That's another person appointed by the court. But here again is an opportunity to state who you would like to raise the child, because sometimes what happens is children with money, unfortunately relatives and maybe an ex-spouse come out of the woodwork in order to raise these children who now have money and also become their legal conservator.
Well, right.
With these funds.
I imagine that they say that that victory has 1,000 fathers and defeat is a stepchild. And when kids get money, I imagine a whole bunch of people show up and say, hey, I want to take care of this child.
Yes, that can happen. But even though there are sometimes challenges to the will, I don't want your listeners to become afraid of doing a will or shy away from it for that reason. It is important to have in writing how you would like to have your assets distributed. I often would tell clients when I practiced in that area, if you don't have an estate plan, the state of Michigan has one for you.
Yeah, they have one for you.
So there is what is called a statute that governs intestacy. And that is what happens when you die without a will. There is an actual statute or a series of statutes that will establish who inherits your money.
Well, that must be pretty tough, though. I mean, then you have to go through an entire process. And I can see that would establish a lot of advocacy, people on one side saying, well, I think that he told me this or she told me that, and on and on and on. So if the state takes over and says we're going to follow the laws we have for people who die without a will, that becomes a more complicated thing.
That becomes complicated from the standpoint that, once again, it may not be the way that you would have wanted your assets to be distributed.
Right.
And I'll give you a case in point. The statute says that, and I will usually explain it in this way, assets go over, down, up, over, down, up. And what that means is, if you do not have a will in place, the first line goes to your spouse. If you have no spouse, it goes to your children. If you have no children, it goes to your parents. If there are no parents, it then goes to your siblings. If there are no siblings, it can go back to your grandparents or the descendants of your grandparents, which then become aunts and uncles, and then cousins. So you may have a situation where individuals are inheriting your assets that you would never want to have.
That you never talked to, that never came over for Christmas.
That never came over for Christmas, you're absolutely right. I think it's also important when you have children from a first marriage and you do not have children in that second marriage. In a lot of cases, even if these are adult children, you may want your children to inherit your assets. If you do not have a will, the statutes establish that the first line, again, is your spouse. Your spouse will inherit your money up to, in the state of Michigan, as of 2012, it was $150,000. So the first $150,000 of your assets go automatically to your spouse. So, for example, if you have a relatively modest estate of $100,000, the first $150,000 goes to your spouse, so there's literally nothing left for your children, unless you have a will that states otherwise.
Okay, well, jointly held property would automatically go to the
Jointly
wife
held
or
property
husband.
is different. Jointly held property does not go through the probate process.
Right.
So if you and a spouse own a home together and it's joint with rights of survivorship, that house belongs to your spouse upon your death. But if that house is your house alone, and it has never been transferred to the two when
Right.
you went through this second marriage, that could still be your property at death. That property now becomes the property of your spouse
Up to
$150,000. And again, you may have wanted your adult children to participate. Without a will, that won't happen. And that's where a lot of the angst in families sometimes occurs, when there are children from a previous marriage.
There was a time, I recall, that I thought the state of Michigan gave people blank forms, wills, living wills, the patient advocate, and things such as that. Do they still do that?
They still do that, and you can still get those forms in a lot of different places. When we talk about a complete estate planning package, typically we're talking about a will, a trust document, a financial power of attorney, and a medical power of attorney that's sometimes referred to as a living will.
Now, the medical power of attorney is for someone who goes in for an operation, and does that person have the right to make life and death choices?
A medical power of attorney will actually give what is called an agent the opportunity to make life and death choices based upon a certain set of circumstances that have already been prescribed in that document. And I think one of the most important cases that we've had that actually, as you probably know, went all the way to the U.S. Supreme Court was the Marianne Schiavo case. And that was a case in which a young woman was on life support, and she did not have a living will or any document that indicated at what point she would like to have the plug withdrawn, so to speak. And she had her parents who wanted her to stay on life support and a husband who wanted to terminate the life support. And the case went all the way to the U.S. Supreme Court to try to determine what would have been her wishes. So a medical power of attorney is an opportunity to state when you would like to have life support measures observed and who gets to make that decision.
Do the hospitals require these documents, or a document such as that, before surgery? And
hospitals generally always give you the option. They will ask you, if you're coming in for surgery, do you have such a document, or would you like to do one prior to the surgery? You can decline. So it is not required, but it is always always asked.
So as a rule, people do give that power to someone.
It's nice to give that power to someone that you've discussed that option with. There are some individuals that want to stay on life support no matter what, as long as possible, and they will tell their loved ones, don't pull the plug. If I'm in a coma, I'm fighting my way back.
Really?
And please give me as much time as possible. Others will say, I don't want to live under those circumstances, and please do what's necessary to make sure that I continue to have some dignity.
Well, it's hard for you and I to sit here and talk about, you know, these people who say, I want to be on life support until I can no longer be on life support. Well, I know of a woman who's been in a coma for 7 years, and the machines keep pumping, and the food is fed intravenously, and I say, toward what end? I mean, but I'm sitting here of sound mind at this point in time saying, if I come out of this coma 7 years later or whatever, am I going to be the same person? I mean, you know, and doctors would sit there and say, well, we can't keep doing this because we know that there is no end, no proper end to this, but they can't have the liability of saying, well, we're going to turn off the machines.
And that's the wonderful thing about a medical power of attorney, is that it is the individual speaking.
Right.
Prior to this incident, it is their decision. It's a personal decision, and it gives them an opportunity to make a personal decision as to how long they would like life-saving measures to take place. And so the document is one that the courts will respect and allow the doctors and the family members to adhere to.
There just seems to be so much notoriety when it's such a simple solution. For example, I think in Rosa Parks' case, someone called me and they just went at it as to who had the rights to her name and who had the rights to her documents and things such as that. And I'm thinking, well, she had a will. And then they said, well, she was under someone else's influence. Well, you know, when you're aging and you're sick and you're not well, I guess anyone can say, well, there was the start of dementia, there was the start of Alzheimer's, things such as that. So the suggestion would be to say to people, wake up. You know how the journey ends. It ends the same for everyone. Let's get a will done. You know, but people shy away from that. They just don't want to think about it.
And I think, Henry, it's because many of us don't like to think of our demise. We'd all like to think that there's going to be some miraculous pill or some miraculous discovery before our time comes. I have found, however, that clients who have come into my office when I practice law, who had finally made the decision to put their affairs in order, had such a sense of relief. And it was such a burden had been lifted, a weight had been lifted, because they knew that when the time came, they wouldn't have to have that thought, I should have taken care of my estate plan. It was done. And once it was done, they felt so, and that's the word, relieved, to know that their affairs were in order. And now they could live the rest of their long life knowing that their affairs were in order. And they wouldn't leave a lot of litigation, and they wouldn't leave a lot of uncertainty to their family. And even though an estate plan can be challenged, it is still, you have some idea, and the courts have some idea of what that individual wanted. You can challenge it under those areas, but you may not win just because you challenge it. And it's better to have the individual's wishes in writing than to have nothing at all.
Is there a document that you can think of where a person is, say they have Alzheimer's, say they have dementia? Is there a way to write something that says, if I have an illness that is disabling me and I don't have cognitive thought ability, is there a way, is there something that you can write that would the court would respect and say, you wanted so-and-so to be your guardian, I'm appointing so-and-so? Is there, I don't know what it's called, is there such a thing?
Well, one of the wonderful things about a trust, for example, is that in a trust you can become your own trustee initially. But there's also language in your trust that states what happens should you become incapacitated and can no longer function as your trustee. You can even have language in this document that says your incapacity has to be determined by 2 medical doctors or 3 medical doctors. It can state the time period in which this has to occur, so that there's some language that says this is what will determine when I'm incapacitated. And this is what will happen should I become incapacitated. The next person will become my successor trustee. And if that person is not eligible or available to serve, then person number 2 will become my backup successor trustee. Typically you name 3 people.
Yeah, but that's a good idea. But you walk into a probate courtroom and you see the son and the daughter. Son's on one side, daughter's on the other. Mother has a breathing machine, and they both want to take care of her. There are no documents. It's the judge's call, I guess. But I've seen a fight over this.
Yes, and now we're talking about the difference between having private documents and having to go into the probate court. If there is a private document, such as a trust, that determines when one becomes incapacitated and who takes over, there then becomes no need to petition for a guardian or a conservator in the probate court.
Do you need a lawyer to do this trust, or can you do a trust yourself?
You can do a will yourself. I would advise individuals, because trusts are contracts to a large extent. So if we're talking about issues of contract law,
they get a little more complicated.
It becomes a little bit more complicated. And that's where you want to make sure that you don't have language in one part of the trust that's contradictory to language in another part of the trust. You want to make sure that the language is clear. That's where it would probably best serve you to make sure that an attorney reviews it. Trust documents differ from wills in as much as a will is publicly probated. As you notice, there are lots of celebrities who pass on, who have a will and have a trust, but because the will is a public document, it does not have to name exactly who takes or what you're doing or who you're distributing your money to. That information is contained in the trust, which is private.
It's private. Okay.
And that's the reason a lot of people will choose a trust, because it is a private document.
I ran across a man who had cancer, and he had delineated exactly who he wanted for pallbearers, where he wanted to be buried,
Yes.
who was going in what car, what he was going to wear, and where the afterglow was going to be held,
Yes.
and who should sit where, and do all that stuff. So I just want to tell you, and that still is being fought. But I just want to thank you. We're running out of time, so
Oh, we could talk about
Judge, I
this
just
for
want to thank you so much for being
hours.
here. And the final word is, do a will.
Do a will.
I mean, you can write it by hand, and it's an easy thing to do.
If you don't have an estate plan, the state of Michigan has one for you.
Yeah, and you don't want the state to have one for you. Thank you so much. I really
Thank you.
appreciate you being here. And let's hope that people take away from this conversation something that will save them or their heirs a lot of grief and a lot of aggravation. And the money will go to the people they want it to go to, or the assets will go. I mean, there's a lot of things that are important and have value that you can't put a number on it.
Major funding for due process is provided by Meade Lexus of Southfield and Meade Lexus of Lakeside, offering a large selection of new and pre-owned certified premium vehicles.
Don't just reject convention. Drown it out. Introducing the all-new 2013 Lexus LS F Sport, an entirely new pursuit.
And by WWJ News Radio 950, keeping you up to date with the latest news, traffic, weather, sports, and business information 24 hours a day, 7 days a week. Live, local, and committed to Michigan's future. News Radio 950, WWJ.